Hey everyone, this is Laura from The Real Laura B here on YouTube and Twitter. I am bringing you today part two in the filing of assignments of errors in the appeal between Depp and Heard, Johnny Depp and Amber Heard. They have both filed their assignments of errors or designations in the case. Johnny Depp has filed additional assignments, and that's part of what we're going to cover. There's also been some questions about what Amber was claiming, and I found some video from the trial where both sides, mostly Amber Heard's side, put in some proffers of objections that might help us with that. So that's what I'm going to be talking about today. So let's get started.
Hi, I'm Laura, also known as The Real Laura B from Twitter, and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer, nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
And I think for this, it's best to just jump right in with a great preview that Law and Lumber Rob did on Twitter. And this is a flow chart he's done, and I've blown it up just a little bit. Let me go back to its original size so you can see what it looks like. But I'm going to zoom in it so that we can read what's been going on so far. So these are the steps. This is part one, assembling all the records before the briefs are filed. So what we've known so far, and let me zoom in as far as I can, the Court of Fairfax has sent over by electronic documents. We now know Andrea Burkhart confirmed that. The record is filed with the Court of Appeals. Everything's been sent over by Fairfax. At this point, a designation of appendix identifying parts of the record relevant to the Court of Appeals is to consider. So that's been sent over. And this, I haven't seen anything specific, but at this point, all of that has been sent over to the court. What happens next was that there was a designation or assignments of errors that had to be filed within 15 days, which they both did. What Johnny now has done is filed cross designation of errors on Amber's appeal. As of today, the deadline's passed. Now Amber has not. Now I've talked to a Virginia lawyer, and she said that it's rare to have cross designation of error in Virginia, but Johnny did file some. So I guess because he filed some, Amber will have, this is what appellant did. Johnny did. He filed within 15 days, October 21st. So now Amber will have a chance in 10 days to answer toward his files. The brief schedule does not change. So we'll still have the brief schedule coming in October 2nd. So this is the file, just to give you an example what it looks like. I don't think I can zoom in too much, but this happens to be Amber Heard is appealing. Her lawyers, we know the first three have now left. They haven't updated that. So Amber Heard is the appellant. Johnny is the appellee. The record was received from Fairfax on July 21st. I'm sorry, they filed their appeal on July 21st. The record was received September 23rd. Amber filed her 16 points of assignments of error. Friday, October 21st, Johnny filed some additional assignments in error. And I guess if she has an option to answer in 10 days. So as far as we know, the opening brief will be due 40 days later, which would be November 2nd. So let's look back to Johnny's. Here we go. This has got to be it. Okay, appellee. He's the appellee. Remember, this is Amber Heard versus Johnny Depp. By and through his undersigned counsel, while not appealing the verdict in his favor, hereby submits the following additional assignments of error in the nature of cross error in the event of a remand. The trial court erred in denying Mr. Depp's motion to deny Ms. Heard's plea in bar with respect to anti-SLAPP immunity, and in denying Mr. Depp's motion to summary judgment with respect to Ms. Heard's anti-SLAPP defense. He's preserved it. Now he's he's page numbering anything, and this happened January 29th, 2021, and the trial court denied him on March 21st, 2021. Plaintiff's memorandum in support of motion summary judgment as to the defendant's anti-SLAPP immunity, which motioned the parties argued and the trial court denied March 24th, 2022, as further reflected in the trial court order. Also, Depp claims the trial court erred by excluding the expert testimony of Dr. Kimberly Collins, a forensic pathologist retained and designated by Mr. Depp. preserved. The parties argue about the admissibility of Dr. Collins' testimony. Trial day 23. So these are all the designations which the trial court excluded. Mr. Depp also made a proffer. We're going to be talking about some proffers before the trial court on this issue. Trial day 24. The trial court erred in overruling Mr. Depp's objection to jury instruction C, which required the finding that the statement was false, instead of adopting Mr. Depp's proposed edit, which required a finding that the defamatory implication of the statement was false. Denying Mr. Depp's request to conform the special verdict form to instruction C, which was given to the jury over Mr. Depp's objection. And he's preserved those with the designations. Object to improper argument, and motion for curative instruction and revised special verdict form was denied. So as I recall, they're arguing that maybe the statement was true, but the implication that Johnny was the cause of the DV was false. So I think that's why he wants it in. And I think they're also trying to show the judges in the appeals court that don't let, if she's going to argue like we were stuck with this, if they find an error in it, he can say, no, they demanded it. So that is that. Now I have Miss Heard's. So here are Amber's. And she split 16 points, but what was noticed was that she did not put in any of her designations of page numbers and stuff. So there's a video I shared, and I'll share it below, and there's also be another video. Andrea revisited this. Apparently there is a statement, if the records are sent over in digital format, you don't have to make the designations in your designation of assignments of error, but you have to in your brief. So we'll see what happens when this is coming up. But what I want to mostly follow today is the trial court erred in excluding from evidence at trial medical records, including Ms. Heard's contemporaneous communications with medical providers, such as all these medical people. We'll get into that. Communications with several third parties, including Mr. Depp's employees, Ms. Heard's employees, friends, family, about interactions with Mr. Depp, including reports of drug use, aggressive and abusive conduct, etc. So that's what I'm going to be talking about today. And this is the proffers. So I guess I'm rushing this a bit, and I don't mean to. So we've gone through the appeals step by step. They filed everything they need to file so far. Everybody's on time. It's mostly in the appeal filing error in law, not error by the jury so much, error or at all. It's error in law. Judge Ascarati made this mistake. Judge White made this mistake in interpreting the law. So they have proffered their objections that they also want to be on record. And let's take a look at that. Okay. So let's start off with, this is day 21.
Yes, the testimony that the court has sustained objections.
So Depp team objected during, this is when they, on Fridays when they were reviewing the video depositions, and there was objections back and forth about what should be included. And these are objections that Depp team made that were sustained. So the videos were edited, what were shown, the testimony part of the deposition was edited to shown to the jury.
Here, Your Honor, it's a box here. So
I think that's fine. You can stay there as long as you stay close to the microphone. Okay. I appreciate it.
And Your Honor, what I will do is I'll explain what.
Where do you see the panic on her face? Because she thinks he's going to read through this entire binder. Now, I will say I am in the court this day, and we had trouble hearing this. Apparently, the mics pick it up much better than what we hear in the courtroom. So I was confused by some of this, but I'm so glad that I'm now able to review this at proper volume.
We're proffering the evidence for, and then we have copies.
Good.
Which I'll provide to you. We'll provide them to you electronically, or I don't have another copy for you right now, but we'll provide.
That's fine. Go ahead. Yes, sir.
Okay. Your Honor, for Laurel Anderson, on March 31st, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial. Dr. Laurel Anderson, a clinical psychologist who worked with Ms. Heard and Mr. Depp. Dr. Anderson testified in the therapy session. Ms. Heard reported to her that she was slapped by Mr. Depp, that he hit her in the head, had her hair pulled by Mr. Depp, kicked her in the leg, and that Mr. Depp gave Ms. Heard bruises. Ms. Heard also reported that Mr. Depp was the first to initiate any violence. Ms. Heard also reported that she hid in a bathroom to protect herself from Mr. Depp. Ms. Heard also reported to Dr. Anderson that Mr. Depp threw a phone at her on May 21st, 2016, hit her and held her hair. Ms. Heard also reported to Dr. Anderson that she was a victim to Mr. Depp's abuse. The testimony is contained in Dr. Anderson's deposition transcript, which is Exhibit A. The court also excluded records of Dr. Anderson from Ms. Heard's and Mr. Depp's therapy sessions and a treatment summary, which are Exhibits B and C. Mr. Depp objected to Dr. Anderson's testimony as described in medical records, stating that they were hearsay and that they did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objection on the grounds that the testimony and exhibits were hearsay.
And we're going to hear a lot of that, and we have heard a lot of that. Again, this is a therapy session, not I don't know how to compare it, a medical section, medical doctor's therapy, where it's only Amber Heard telling her therapist what happened. I find it interesting about her hiding in the bathroom because, I mean, we've heard on audio tapes it's Johnny who hides in the bathroom. We also have to remember, as I recall, Dr. Anderson had reported that Amber Heard actually called her during the day, December 15th, about the incident, which was kind of before it happened, and that she had asked, should I call the police? Would that help me in a divorce? So get it on record. Here's some more.
For Dr. Kipper, on March 31st, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Dr. David Kipper, Mr. Depp's physician. Dr. Kipper testified Ms. Heard voiced concerns of Mr. Depp's behavior while on drugs and alcohol, that Mr. Depp tried to fight and push Ms. Heard while he was attempting detox on his island, and that she found lots of cocaine in February 2016. Dr. Kipper also testified he told Mr. Depp to, quote, bury the dragon, which referred to the bad feelings that Mr. Depp has inside him. This testimony is contained in Dr. Kipper's deposition transcript, which is Exhibit D. Dr. Kipper also testified about an email he wrote explaining Mr. Depp's detox treatment. In the email, Dr. Kipper wrote to Mr. Depp's sister that Mr. Depp had fundamental issues with anger, romanticized the drug culture, and had no patience if his needs were not met. This email is Exhibit C. Exhibit E. Mr. Depp objected to Dr. Kipper's testimony and the email stating it was hearsay, that it did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objection on the ground that the testimony and exhibits were hearsay.
So these are things that appeals judges are going to decide whether Judge Ascarati made correct decisions on these. Were they hearsay?
Deborah Lloyd. On March 31st, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Debbie Lloyd, Mr. Depp's nurse. Ms. Lloyd testified Ms. Heard voiced concerns about Mr. Depp's behavior while on drugs and alcohol, and that Mr. Depp worked himself up into a rage and was trying to fight Ms. Heard while he was attempting detox on his island. This testimony is contained in Ms. Lloyd's deposition transcript, which is Exhibit F. Also, Ms. Lloyd kept nursing notes on these issues that she testified to, which is Exhibit G. Mr. Depp objected to Ms. Lloyd's testimony and portions of the nursing notes, stating it was hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objection on the ground that the testimony and portions of the nursing notes were hearsay.
Again, we're always getting into this he said, she said. She is reporting this happened with no corroboration. So I guess it's hearsay. This is what Judge Ascarati has decided, all of this.
Aaron Borum-Filati. On March 31st and April 1st, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Ms. Filati, Ms. Heard, and Mr. Depp's nurse. Ms. Filati testified that Ms. Heard reported to her on December 16th, 2015, that Mr. Depp headbutted Ms. Heard in the forehead. This also was contained in Ms. Filati's nursing notes, which is Exhibit H.
That's interesting. Headbutted in the forehead, when all along she's been saying intentionally, with full force, with premeditation, in her nose.
Ms. Filati further testified that Ms. Heard reported being freaked out after the December 2015 incident and testified to text messages between herself and Ms. Heard, where Ms. Heard reported the incident of abuse. These text messages are Exhibits I, J, K, L, and M. Ms. Filati also testified that on May 21st, 2016, Ms. Heard reported that Mr. Depp became completely delusional and crazed and hit Ms. Heard in the face while she was on the phone with I.O. Tillett-Wright. Ms. Filati testified to text messages reporting this as well, which are contained in Exhibit N. The testimony is contained in Ms. Filati's deposition transcript, which is Exhibit O. Mr. Depp objected to Ms. Filati's testimony, portions of the nursing notes, and the text messages referenced stating it was hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on the grounds that the testimony and portions of the nursing notes and the text messages were hearsay. Amy Banks, Dr. Amy Banks. On April 29th, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Dr. Amy Banks, a clinical psychologist and relationship consultant who worked with Ms. Heard and Mr. Depp. Dr. Banks testified that in therapy sessions, Ms. Heard reported that Mr. Depp attacked her physically, including by hitting her with his hand. Dr. Banks also testified that Ms. Heard reported that Mr. Depp cut his finger off and burned himself with a cigarette. Dr. Banks also reported that Ms. Heard told her that Mr. Depp initiated the violence while in a session with Mr. Depp, and Mr. Depp did not object to the characterization of the violence. Finally, Dr. Banks testified that she believed Ms. Heard's accounts of the violence and that Ms. Heard was a victim of domestic abuse. This testimony is contained in Dr. Banks's deposition transcript, which is Exhibit P.
And I think that's one of the things that Elaine was pushing on the talk shows. Again, it's therapy, client, patient reporting to the therapist, no corroboration, hearsay.
Mr. Depp objected to Dr. Banks's testimony, stating it was hearsay that did not fall into any exceptions, including statements for purposes of medical treatment and for providing improper expert opinion. The court sustained the objections on the grounds that the testimony about the abuse was hearsay and that Dr. Banks's testimony that Ms. Heard was a victim of domestic abuse was improper expert opinion. Connell Cowan.
Before we go any further, I do want to mention that these things were considered in Dr. Hughes's testimony. So they were considered through her evaluation as an expert witness. I do remember her quoting these doctors.
On April 29th, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Dr. Connell Cowan, a clinical psychologist who worked with Ms. Heard. Dr. Cowan testified that in the therapy session, Ms. Heard reported abuse by Mr. Depp, including text messages and medical notes, where Ms. Heard reported in December 2015 that, quote, "Johnny did a number on me," end quote. This testimony is contained in Dr. Cowan's deposition transcript, which is Exhibit Q. It is also contained in Dr. Cowan's medical notes in Exhibit R at Dep 9122 through 23, and is contained in text messages that are Exhibits S and T. Mr. Depp objected to Dr. Cowan's testimony, stating it was hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on the ground that the testimony about the abuse was hearsay. Alan Blaustein. On April 29th, 2022,
Now just jumping in, that is Johnny's therapist.
the defendant attempted to designate certain portions of the deposition testimony for trial of Dr. Alan Blaustein, a clinical psychologist who worked with Mr. Depp. Dr. Blaustein testified that in the therapy sessions, Mr. Depp reported that he had cut himself as a child and burned himself with cigarettes. Dr. Blaustein also testified about the drugs that Mr. Depp was on, as reported to him by Ms. Lloyd. This testimony is contained in Dr. Blaustein's deposition transcript, which is Exhibit U. This information was also contained in emails, which are Exhibits V, W, and X. Mr. Depp objected to Dr. Blaustein's testimony regarding the cutting and burning himself as speculation, and the testimony regarding the drugs Mr. Depp was taking as hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on these grounds. Bonnie Jacobs. On May 4th, 2022, the defendant attempted to introduce into evidence the treatment notes of Dr. Bonnie Jacobs, a clinical psychologist who worked with Ms. Heard. The treatment notes show Ms. Heard reporting abuse by Mr. Depp, including sexual violence. The treatment notes are Exhibit Y. And based on the court's ruling, the defendant did not call Bonnie Jacobs as a witness. Mr. Depp objected to Dr. Jacobs' notes as hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on those grounds.
So I think this is interesting. Now, a lot of law tubers have covered this. This is pretty standard rulings for therapists, non-medical treatment, that it's hearsay. So it'll be interesting how the appeal judges rule on this.
I have some more.
Oh.
As long as you don't just keep turning every page in that book.
No,
I'm not staying for that.
It is not.
Okay.
The UK judgment. On April 29th, 2022, Ms. Heard moved to allow evidence and questioning regarding the UK judgment and for admission of the judgment itself, which is Exhibit Z. In support for her motion, Ms. Heard argued that Mr. Depp had opened the door to the admission of the judgment by presenting evidence of damages after the date of the judgment on November 2nd, 2020. For example, Ms. Heard observed that Mr. Depp had sought damages for losing his role in Pirates of the Caribbean 6, a movie that's not yet been made. Ms. Heard further observed that Mr. Depp testified that the op-ed had caused him and his family irreparable harm, thereby suggesting that his reputational harm had continued to the present. Ms. Heard noted that Mr. Depp's expert designation indicated Michael Spindler relied on Mr. Depp's earnings from 2019 to 2021 when reaching his opinion, which resulted in an amendment to the designation. Ultimately, the court found that Mr. Depp had not opened the door to the admission of the UK judgment and overruled the motion, which the court did again today with Mr. Banya's opinions.
I think Mr. Banya was very specific in saying I think I have the right ones, with the op-ed, that her op-ed was basically a call to action when she wrote it. It's a call to action to Hollywood to say, hey, don't work with this guy anymore. Don't hire him. So that wasn't pretty much immediate afterwards that he heard from Disney, that he read about Disney dropping him. The prior article that they kept talking about with, I think his name was Beatty, he was a writer on the first Pirates. I think they rewrote a lot of his script. He had nothing to do with the future Pirates. He had no way of knowing whether Johnny was going to continue. It was just an odd question that was thrown at him, a what if question if Johnny was no longer involved. But for all intents and purposes, 3 days after she had the op-ed, a Disney executive did confirm they were going to try and take another path.
Finally, Adam Bercovici. On May 19th, 2022, Ms. Heard attempted to call Adam Bercovici, who was an expert in the policing and Los Angeles Police Department policing of domestic violence calls for service. Mr. Bercovici would have testified to his qualifications in the field of policing and LAPD policing of domestic violence calls for service as follows, and further outlined in Ms. Heard's fourth supplemental and rebuttal disclosures dated March 31st, 2022. Mr. Bercovici spent 30 years with the LAPD, retiring in 2012 at the rank of lieutenant. He has extensive experience as a patrol officer, field supervisor, uniformed watch commander, both as Sergeant Second and Lieutenant One, along with multiple assignments as an officer in charge, Lieutenant Second of specialized detective units. During his tenure with the LAPD, Mr. Bercovici held numerous positions directly responding to and overseeing subordinate officers' responses to the domestic violence calls for service, including as a patrol officer, supervisor, watch commander, and assistant watch commander. And actually this, Your Honor, is the person who prepared this, prepared a longer brief of what he was going to say.
Amber Heard just seems so in control of her team, making sure they do all this. It just looks odd to me. But I don't remember in her assignments of error anything mentioning the LAPD.
Is it okay to just submit it rather than hearing me read it all?
Any objection to that?
No objection.
No objection. Okay.
Okay.
That's fine.
And with that, that's
Okay.
proper.
You just scared me with the size of that.
No,
picture. Wanted to-
Johnny's like, I just want a cup of coffee.
All right, that's fine. If you can get Jamie our copy of it, we'll make sure it becomes
course,
part
sir.
of the record as well.
Thank
Okay.
So this was on
All right. Do you have any proffers, Mr. Chu, that you need to, at this point?
Not at this time, Your Honor. Thank
Okay.
you.
All right. Then I think there's just a couple things I need from you.
And that's pretty much it. So that was the day 21 proffers. So we get an idea of the kind of things she's bringing to the appeal that were not so spelled out. They will be spelled out, the briefs. If she decides to still keep those points in. Remember, she's put 16 points in. That doesn't mean she has to still claim all those 16 in her appeal brief. She's just put on the table. It's kind of like, it reminds me of affirmative defenses. If you don't claim it then, you can't claim it later. She's put in her assignment of errors. That doesn't mean she's going to choose all of those for her brief. So let's go to the next group of proffers. And I think we're right where we need to be.
Has a proffer still on some things.
Oh, yes,
Do
okay.
you want to do that now? before we-
Yes, sure.
As does
Yeah,
Ms.
everybody
Myers.
wants to hear your
I have
proffers.
to-
As does Ms. Myers at the end of Mr. Nadelhoff's.
Yeah, okay. All right, they have one too. So that's all right. Go ahead.
Yeah. This will
If
be
you can just get to
shorter.
the microphone
Yeah.
so I can hear you better. Or the court reporter can hear you better.
This will be shorter than the other day.
Oh, good.
Okay, this is for metadata. On May 16th and May 17th, 2022, the defendant attempted to introduce into evidence photographs from May 21st, 2016 that included metadata on the photographs. Ms. Heard testified that the metadata was included on the photos by pressing a button on her phone. The metadata demonstrated the pictures were taken on May 21st, 2016, along with the times they were taken. The exhibits or defendants exhibits 700 through 726, and are exhibits A through AA of the proffer. Tabs N and O of the proffer are now blank, as defendants 712 and 713 were admitted with the metadata on May 26, 2022. Mr. Depp objected to the metadata on the document, stating that the metadata was hearsay and there was no foundation for the hearsay. The court sustained the objection on the ground that the metadata was hearsay and that there was no foundation, and admitted the exhibits, but redacted the metadata.
I would love to know the full argument on this, other than we know they show two photos that were taken at the exact same time, the exact same day, and they looked very different with the exact same metadata. So I think that's why he's upset that metadata was shown on some photos and not other, and that's how they rebutted her. I don't know. She's saying it was on her phone. All she had to do was press a button. Well, she testified that she didn't take the photos. Somebody else did. So how did the photos get to her phone? And would that metadata have been accurate? So that's my supposition here. But obviously they had a big hearing on it. It's like all he's reading in his proffers are a general, very basic summary and the ruling. There's a lot more to this, obviously, in the hearing and discussions.
Yeah. And then separately, we have a proffer for Stephen Duders. On May 20th, 2022, Ms. Heard moved to designate certain portions of the deposition testimony for trial of Stephen Duders, who was Mr. Depp's personal assistant.
And we've all asked this question: why didn't Stephen testify? Well, he did give a deposition. They did have video of it. They did try to get some in. Let's see what happens.
Mr. Duders testified that he was on the Boston flight and sat in a seat facing Ms. Heard and Mr. Depp. He further testified that the day after the flight, Mr. Depp told him he wanted to, quote, smooth whatever issue, end quote, existed with Ms. Heard. Mr. Depp asked Mr. Duders to, quote, write a text, end quote, to Ms. Heard and to say, quote, whatever she needs to hear, end quote. Mr. Duders then sent a text message to Ms. Heard about Mr. Depp, stating, quote, when I told him he kicked you, he cried, end quote. The testimony is contained in Exhibit A, Mr. Duders' deposition. Ms. Heard moved to admit the text message into evidence, arguing
She wanted the text messages in evidence, not the deposition. She only wanted the text messages. That's my take on it.
it was not hearsay under Rule 2:803, which provides for the admission of statements of a party opponent and his agents. Ms. Heard argued Mr. Duders was acting as Mr. Depp's agent when he sent the text, and the text message was therefore not hearsay. The text message is Exhibit B to the proffer. Mr. Depp objected to the text message as hearsay, arguing that although Mr. Duders was Mr. Depp's employee, sending text messages to Ms. Heard was not within the scope of the employment. The court denied the motion to admit the text message in testimony, finding that Mr. Duders was not acting as Mr. Depp's agent when he sent the text message.
So this is my takeaway from this. What they tried to do was designate Stephen Duders as an agent, similarly as they designated Adam Waldman. When Adam gave those statements to the newspaper, it was as if he was speaking through Johnny's mouth, standing in Johnny's shoes. They're trying to say the same thing for Stephen, but Stephen, in sending those texts, was not part of his job. They were just friends. He's like, just say whatever you need to say to calm her, to appease her. They apparently did not want his deposition testimony in, where he further explained why he sent those texts. They only wanted the texts, and they said, no, that's hearsay. So that was my take on it. And I racked my brain because I remember hearing about them wanting to designate him as an agent, and I couldn't for the life of me remember where it came from. And here it is. You can't have your pie and eat it too. You can't have your cake and eat it too. You can't have the text without the deposition.
I have copies to provide.
All right, fine. We can add it to
The list. Yeah.
We have a box for you. All right,
No,
we will
here's this.
add that.
Oh, sorry, Eric.
I think he has more.
And this is the other one.
All right, we'll make them part of the record. Thank you, sir.
Thank
All
you.
right, yes, Ms. Myers?
Thank you, Your Honor. On May 25th, 2022, plaintiff intended to call Dr. Kim Collins as an expert witness in forensics pathology. Defendants objected on the basis that Dr. Collins had not been designated as a defensive witness and was designated only to rebut Dr. Jordan, which was defendant's forensic pathologist who had not been put up at this trial. Dr. Collins intended to testify as to whether Ms. Heard's descriptions of violence and injuries allegedly sustained by Mr. Depp were consistent with the photographic evidence at issue in this trial. She also, for incidents where there was no photographic evidence, she would have testified as to what injuries she would have expected to see based off of the violence that Ms. Heard testified to. And finally, she would have testified as to her opinion as to the cause, or as to Mr. Depp's finger injury and what she observed, consistent, which was similar to what Dr. Gilbert testified to today.
All right, thank you. Any other proffers? Okay. All right. So just don't leave here until you check the laptop and you check all your evidence. And
So this was the last day, right before they were going to give jury instructions. When Johnny left, the room emptied out to all run out and see him, and I did stay for this. So that's what I've got for you today. I hope that clears up some of what we think she may be arguing to the appeal court in their brief. We'll see what happens. We know the last one, Dr. Collins, Johnny had just added to his assignment of errors into her appeal. So I hope this helps. I was racking my brain trying to bring some kind of help for you guys. Since I'm not the lawyer, I could at least research it and bring you references. And that's what I'm trying to do. I know a lot of other law tubes who I love are going to go deeper into this. I'll include some links in the bottom regarding the assignment of errors that were filed. And the briefs are due November 2nd, unless someone files. Pretty sure that's when they're due, November 2nd. Yes, unless someone files for an extension for some reason, but that would be rare in this case, I think. So that's about all I have for you today. I'm trying to do some shorter videos so that I don't have you hanging on for so long. I hope that helps, and I will link in the original one that I made on this video too. And these documents, I'm not sure I can share. Again, they're not links that are on a public site. So they're mostly just here. So I hope that helps. By the way, I'm hearing some people are still not getting some notifications. I think I heard that YouTube may have done an update where your bell turned into personalized instead of all. So you might want to recheck your notifications standings. And I hope you will like, share, and comment. And I try and get to you twice a day. And I appreciate everything about you guys. I really do. And thanks so much for supporting me. Thanks again. Have a great day.